gentlemen, and welcome to the third lecture in St. Anthony of Padua Institute's Manhattan Forum series. Our lecturer today is Ernest S. Pierucci. Mr. Pierucci is a graduate of St. Mary's College, don't hold that against him, so am I, and of the Catholic University of America, Columbus School of Law. He's been an attorney in private practice since his graduation from Catholic U in 1975, with the exception of a small, like everybody else, a small fling in California real estate. We're all familiar with that and with how it turns out. He's also presently, and very importantly, Senior Fellow for Catholics for the Common Good, a highly successful, I speak from having read the materials and also having spoken to people, the highly successful marriage training programs which are presently under conduct by Catholics for the Common Good are owing largely to his inspiration and his wisdom. So I'll ask you to welcome Mr. Pierucci to speak to us this afternoon on prospects for marriage and the family in the current legal environment.
Thank you, Steve. Can everybody hear me? Is there a glow off my head that's hurting anybody? No. Steve gave you the title for this little talk. It's The Prospects for Marriage and the Family in the Current Legal Environment. Now, obviously, and to your great delight and relief, we can't cover the entire breadth and depth of this topic in our time here tonight, or this afternoon. I want to focus my talk on what Proposition 8 did and what it did not accomplish. Proposition 8 is an amendment to the California Constitution passed as an initiative in 2008 by California voters. It states, quote, "Only marriage between a man and a woman is valid or recognized in California," close quote. Proposition 8 was passed in response to a 4-3 decision by the California State Supreme Court in a case called In Re Marriage Cases. And that decision was that there was a right under the California Constitution for a person to marry another person of the same sex. Now, it's reported that more money was spent on the election campaign over Proposition 8 than any other election in American history other than presidential elections. Despite the immense public attention and concern generated by Proposition 8, the legal environment for marriage and the family is much broader than the actual impact of Proposition 8. While I think it is crucially important to maintain Proposition 8 as constitutional, all it really does is reserve the word marriage for heterosexual couples. Substantively, California law still understands same-sex domestic partnerships to be the legal equivalent of heterosexual marriages. Are we then reduced to a meaningless argument over a name? What is at stake? I propose to you that what marriage is called by in the law is very important, and that there is another issue inherent in the struggle over Proposition 8, critical to the prospects of marriage and the family under the law. That is, what is the scope of the right of Californians themselves, through the initiative process, to legally define marriage? So, with that as an introduction and hopefully something of a tease, let me do some dry work here and lay out the basic legal framework in which laws dealing with marriage and the family are established here in California. This is kind of the basic grammar of this issue, and bear with me for a moment. The United States of America is a federal republic. The powers of the national government are limited to those granted by the people in the Constitution. I say this recognizing the expansion of federal power through judicial interpretations over the years. Those powers not granted to the federal government are reserved to the states and to the people. One of the powers retained by the states is what is known as the police power. This is a term of art. It means that states have an inherent general power to make laws regulating public welfare, security, safety, and health, subject only to the provisions of the state's constitution. Civil laws regarding marriage and the family are principally the responsibility of states under the police power. However, such laws and all state laws are subject to any applicable federal constitutional and statutory limitations. So, 9th grade civics in 2 paragraphs. In California, the legislative power is essentially shared by the legislature and the people who can enact legislation through the initiative process. Further, under the terms of our 1911 revision of the California Constitution, the majority of voters can, through the initiative process, amend the state constitution. A majority vote by the people of the state can, in fact, amend our Constitution. If the people enact legislation by initiative, the legislature cannot overwrite it, but California courts can declare it unconstitutional under either the California Constitution or the United States Constitution, or find that it's preempted by federal statutory law. So there are hurdles that even a statutory initiative has to go through. However, if the people pass an amendment to the state constitution, the California courts cannot overturn it on the ground that it violates the state constitution, because obviously it doesn't. As to that matter, the voice of the people on amendment to the state constitution is the expression of their sovereign power. Federal courts can strike down a state constitutional amendment or a legislative enactment passed by initiative, either because they find it to be preempted by federal legislation or that it violates some provision or provisions of the United States Constitution. But federal courts cannot strike down a state law because it violates the state constitution. If that matter's already gone up to the courts of our state, and any state, are the last word in what the constitution of that state means. Still hold it to be violative of the federal constitution. From the first California state constitution in 1849, that was, I think, a year or two before I was born, until the California Supreme Court decision in May 2008, in California, the legal institution of civil marriage was understood to refer to a relationship between a man and a woman. However, it was not until 1977 that the legislature added the phrase, quote, between a man and a woman, unquote, to the statutory definition of marriage. This was done at the request of the County Clerks Association to clear up an ambiguity in the language used, and the language that was used to change the age of consent caused in the ambiguity was caused in the statutes. What happened was, it used to be that men would be of a certain age, women of a certain age to give consent, and indeed it was so designated. Then 18 became the age for everyone, and they removed the reference to males and females. And there was no reference to males and females in the code. And so people who, same-sex couples, started to show up and say, I'd like a marriage license, please. And the County Clerks Association, as they had to deal with that, said, we'd like you to clarify this so we don't have to worry about, we don't get in arguments over the counter about this. And the legislature, right readily and without any fanfare, did it. In 2000, the initiative Prop 22 added the words identical to Proposition 8 as a statutory provision to California law. And one of the principal purposes of Proposition 22 was to stop out-of-state same-sex marriages from being recognized in California under the full faith and credit provision of the United States Constitution. Hawaii is where this started to bubble up, as you may recall. And as other states started to consider allowing same-sex marriages, our state was concerned because there was nothing in the Constitution or the statutes that said that such marriages would not be valid in California or recognized in California. And so if somebody got married, say, in Massachusetts, same-sex couple got married in Massachusetts, they could come to California and say, you have to recognize our marriage under the full faith and credit provision of the federal Constitution.